Our next case deals with United States of America versus Kyle Adam Kirby. This case deals with a cop who decided that it was a good idea to maintain possession of child pornography on his work-issued computer. This did not end well for him, and we're going to discuss this in terms of the sentence that he was prescribed. So let's give this a quick read and see what this guy did and the sentence that he was given in terms of that. This appeal requires us to decide whether the United States sentencing guidelines cap on an otherwise recommended sentence of life imprisonment at 470 months when the statute of convictions does not allow a sentence of a life term. A jury convicted Kyle Adam Kirby of 5 counts relating to the production and possession of child pornography. At sentencing, Kirby's total offense level was 43, which incidentally, under the sentencing guidelines, is the highest offense level possible, which means that the guidelines ordinarily recommend a sentence of a life term. But because the statutory maximum punishment for Kirby's crimes was less than a life term, the district court concluded that the guidelines' recommendations of consecutive terms of the maximum sentence for each of the appropriate convictions. So we have 2 different things going on. We have the statutes, which say a range of possible sentences. How much time can you possibly sentence someone for? Sometimes there's a minimum and sometimes there's a maximum. There's some kind of range in the statutes. And then we have the sentencing guidelines. These are auxiliary that sit outside the statutes, but basically say, given your prior history, your prior criminal history, and given how many seriousness of this current crime, it suggests a particular range of sentences that are appropriate. And courts normally stick to this guideline. Now, this guideline used to be mandatory. Courts had to give a sentence within this guideline, but the Supreme Court about a dozen years ago found the requirement unconstitutional because the Supreme Court essentially said that every case has to be heard on its own merits. So now the guidelines are kind of merely strongly suggestive. The courts can deviate from the guidelines either in excess of them or in lower of them, as long as it has some sort of rational basis that it explains in its decision. But in any case, you can't go beyond what the statutes allow. So in this case, the guidelines said it recommended a sentence of life imprisonment, but the criminal offenses did not allow for that possibility. So you can't give more than statutes allow. So in this case, what the court did was it said, okay, well, since the guidelines say I should give a life sentence, but I can't, what I'm going to do is I'm just going to max out everything I possibly can, issue consecutive terms, and that will get me as close as I can. Well, how close? The district court then adopted this recommendation and sentenced Kirby to 1,440 months of imprisonment, which for those of you keeping track at home is 120 years. So I'd argue that's pretty close. Kirby argues the correct sentence is 470 months of imprisonment because the United States Sentencing Commission equates life sentence to that term for statistical purposes. He also contends his sentence was substantially unreasonable, and we disagree and we affirm Kirby's sentence. State and federal law enforcement officers traced 28 video files and 90 images depicting child pornography to the Internet Protocol address of Kyle Adam Kirby, a sergeant with the Live Oak Police Department. A later investigation by the FBI uncovered over 200 images of children being sexually abused on the laptop computer assigned to Kirby's patrol vehicle. He stored the child pornography on his work laptop, and he's a cop. So just, all kinds of special. Kirby, who then for some reason was suspended from his job, responded by asking Sergeant Derek Slaughter to erase files from his account on the department desktop computer. Instead of deleting the files, Slaughter searched Kirby's account and found images of a nude prepubescent boy. So he was suspended from his job for some reason unrelated to this. He said, please delete all my files. And he said, let me not do that. Let me look at the files. And he did. And we found child pornography. So excellent. Slaughter reported the image of to the police chief, who approved a search of the computer. A forensic analysis of the computer produced at least 80 images of child pornography or child erotica. Most of these images were of Kirby's 13-year-old stepdaughter, either captured by hidden cameras in bathrooms or taken while Kirby was assisting his stepdaughter with stretches due to a sports injury. The computer also contained a pornographic image of a friend of Kirby's stepdaughter. So just to add that little extra step, it was of his own stepdaughter, the child pornography. So just Super fantastic. So, for those of you keeping up with the fact pattern, we've got images of child pornography of his own stepdaughter that were stored on his work computer, and once again, he's a cop. So, that's just great. A grand jury charged Kirby with 3 counts of sexual exploitation of children for the purposes of producing child pornography, and 2 counts of possessing with intent to view material involving minors engaged in sexually explicit conduct. Following the trial, a jury found Kirby guilty of all counts. Using the 2016 edition of the United States Sentencing Guidelines, the probation officer assigned Kirby a total offense level of 43, which again is the highest level possible, and a criminal history category of 1. The district court accepted this calculation without objection from either party. As the district court explained, the guidelines ordinarily recommend a life sentence for this offense level. But because none of the counts of the conviction allowed for life imprisonment, the district court concluded the guidelines recommendation, taking the maximum for each count and adding them together for the sentence. And again, without objection, the district court then calculated the guideline sentence as 1,440 months. After considering the statutory sentencing factors, the district court sentenced Kirby to the 1,440 months of imprisonment. We review the interpretation of the sentencing guidelines de novo. We review the substantive reasonableness of the sentence for abuse of discretion. So there they say when you're looking to the judge and what they do in terms of what is reasonable, it's abuse of discretion, which is a pretty high standard. So the trial judge gets quite a lot of latitude as long as it's within the statutory limits. We reverse for abuse of discretion only if we're left with a definitive and firm conviction the district court committed a clear error of judgment in weighing the factors by arriving at a sentence that lies outside the range of a reasonable sentence dictated by the facts of the case. For the first time on appeal, Kirby argues the district court committed procedural error by calculating the guideline sentence as consecutive terms of the maximum sentence for each count of conviction. As a fallback position, he contends his sentence was substantially unreasonable. We address each argument in turn. Kirby argues for the first time on appeal that district court incorrectly calculated the guideline sentence. His failure to object in district court would ordinarily mean that we review for plain error, but because no error occurred, we need not decide whether the alleged error occurred or whether it was plain or effective rights. As Kirby concedes, his total offense level and criminal history category would ordinarily call for life imprisonment, but none of Kirby's offenses call for a life sentence. Look at the statute, which imposes a maximum sentence of 30 years, and look at the other statute, which imposes maximum sentences of 10 or 20 years. So that is what we got. We got multiple counts of sentences and limits are 30 or 20 or 10 years. Okay. So the district court applied the section of the guidelines which explains what to do in this circumstance. If the sentence imposed on the count carrying the highest statutory maximum is less than the ordinary guideline recommendation, the sentence imposed on one or more of the counts shall run consecutively, which means one after another, but only to the extent necessary to provide a combined sentence equal to the guideline recommendation. The parties agree that this section controls our decision. They dispute what sentence is equal to a life imprisonment. The district court adopted a straightforward understanding of a life sentence, that is, indefinite in duration. So it concluded that the guidelines recommendation of consecutive terms of statutory maximum for each count of the conviction, the closest sentence to life that the law would allow. The maximum term for the 5 counts of conviction collectively produced a sentence of 1,440 months of imprisonment, but Kirby contends a life sentence converts to 470 months. He explains that the Commission defines a life sentence for statistical purposes at 470 months, a length consistent with the average life expectancy of federal criminal offenders. The district court correctly interpreted the guidelines. The language of the guidelines, like the language of the statute, must be given its plain and ordinary meaning. And the meaning of a life imprisonment is clear: confinement in prison for the remaining years of his or her natural life. By definition, life imprisonment lacks a fixed term. So the district court correctly combined the statutory maximum for each count of the conviction to send Kirby's guidelines to 1,440 months of imprisonment, the closest available sentence to indefinite incarceration. The definition of life imprisonment in a statistical sourcebook published by Sentencing Commission does not alter this conclusion. To start, the statistical sourcebook is not part of the sentencing guidelines. The Commission publishes the sourcebook based on its authority to collect and publish data on the sentencing progress. The report also satisfied the Commission's obligations to provide an annual report of sentencing data to the United States Attorney General. But the sourcebook does not amend or redefine the guidelines in any way, which would require the Commission to approve it by an affirmative vote and submit it to Congress for review. As the First Circuit held, though 470 months may be an accurate statistical summary and representation of the length of many life sentences, and may be indeed equivalent to a life sentence in many individuals, there is no cap within the guidelines that limits life sentences to 470 months. And although one circuit has approved the use of 470 months as a baseline to calculate a reduction in sentence for substantial amount of assistance to the government, no circuit has defined life imprisonment as 470 months. The Supreme Court has defined a life sentence as the second most severe punishment known to the law, and we cannot accept Kirby's invitation to hold that a 1,440-month sentence is worse. We instead conclude that when the sentencing guidelines recommend life imprisonment, they mean life imprisonment. Accordingly, the district court did not err procedurally when it calculated the guideline sentence so as to close to the indefinite incarceration as the law allowed. Kirby also contends his sentence is substantially unreasonable, which requires him to establish the district court failed to afford consideration to relevant factors that were due significant weight, give significant weight to improper or relevant factors, or commit a clear error of judgment. Substantively unreasonable sentences are rare, and they are. The appeal courts are not prone to overturn things that are within the judgment of the lower courts, unless they're outside the bounds of reasonableness. And they have to be pretty unreasonable at that, too. We also ordinarily expect a sentence within the guidelines range to be reasonable. As an initial matter, Kirby's argument is largely predicated on the erroneous conclusion that the district court imposed an above-guideline sentence. Regardless, the sentence was not unreasonable. Before imposing the largest sentence it could, the district court thoroughly discussed Kirby's particular heinous conduct and direct participation in the creation of child pornography, his breach of public trust as a police officer, and his total failure to take responsibilities for his actions. We see no abuse of discretion, and we affirm the sentence. So that is the end of the story of Kyle Adam Kirby. Now, I will give one item of good news for Mr. Kirby, out there. Unfortunately, the United States federal government long ago abolished parole. Parole is no longer a thing in the United States federal system. However, one item of good news is that you can get credit for good behavior in court and good behavior in jail. It's meant as an incentive to help encourage people to behave better. So you can get some good time credit, and you can get up to 15% of your time credited. So he may not have to serve 120 years. He may only have to serve 85% of that. So that would be, that'd be roughly minus 20 years. So he may only have to serve about 100 years of the 120 years of his sentence. So, hey, there's one item of positive news. So if he's really, really good, maybe he'll get out sometime around the year 21, 22, if I did my math in my head correctly. So we'll see what happens when that date rolls around.